My case report is on the Humane Society of the United States versus Mike Johanns. This is part of the ATE 3515 Legal and Ethical Issues in Veterinary Technology. Teacher is Dr. Cynthia Gray, and this is presentation for June 19th, 2023. For this case report, we will be discussing information about the case, background information about the case itself, and the ruling. Information about the case. The country of origin is the United States District of Columbia. The case number is 06265 CKK. The judge who ruled in this case is Colleen Kalarkali. The plaintiff is the Humane Society of the United States. Defendant is Mike Jones, and date of decision of this case was Friday, April 13, 2007. Background information on the case is in 2006, nearly 105,000 horses were slaughtered in the U.S. for human consumption, with the majority of the meat being brought to European Unions and Japan markets. In February 2006, President Bush signed legislation as part of an omnibus bill preventing the U.S. Department of Agriculture from spending funds to pay federally required USDA inspectors at horse slaughter facilities. And most of the horses that were raised for purposes other than food production were in good condition before being slaughtered. The price of horse meat outweighed the benefits of keeping the animals alive, and that prompted Congress to add the Agricultural Appropriations Bill to prohibit federal funds to pay for the inspection of horses being slaughtered for human consumption. Also, the Animal Welfare Institute, along with other humane organizations and individuals, challenged this action. The Animal Welfare Institute and its co-plaintiffs challenged the rule on the grounds that it violated requirements of the National Environmental Policy Act and the Administrative Procedure Act. The U.S. petitioned USDA for an emergency rulemaking to create a free for-service inspection program that would have allowed horse slaughter facilities to continue operations. The failure of the USDA to comply with the Administrative Procedures Act and failure to conduct environmental review under the National Environmental Policy Act was the subject of the U.S. versus Johanns. The issue in the case involves a dispute over the creation of a fee-for-service anti-mortem house slaughter inspection system by the USDA without first conducting any environmental review under NEPA, which is the National Environmental Policy Act. The plaintiffs alleged that the system was created in violation of the 2006 Agricultural Appropriations Act Amendment and the Federal Meat Inspections Act. The USDA created a fee-for-service inspection system for house slaughters, but it's being disputed due to alleged violations of environmental and administrative laws. At the time the plaintiffs filed their complaint, horses were slaughtered at 3 different foreign-owned facilities in the United States to provide horse meat for human consumption aboard and for the use in zoos and research facilities domestically. Based on the court findings of a NEPA violation, the court declared the interim for final rule to be a violation of the APA and NEPA. The court notes that as of March 28, 2007 order, CAPA was the only facility still in operations processing horse meat for human consumption. The Humane Society accused Johanns of violating NAPA by implementing new regulations without conducting an environmental impact statement. Witness statements indicated that living in the vicinity of the horse slaughter plants, they would find horse blood in their bathtubs, sinks, and toilets. It was undisputed in Johanns that horse slaughter operations significantly impacted the environment. Couple of acts or laws that are involved with the ruling of this case is the Federal Meat Inspection Act, the Federal Agriculture Improvement and Reform Act, and also the National Environmental Policy Act. The inspection personnel's related to these acts, what they do is they conduct inspections of facilities that slaughter livestock and prepare meat and meat food products. Therefore, they determine whether the establishments maintain sanitary conditions. The Federal Meat Inspection Act. This is an American law that makes it illegal to misbrand meat and products being sold as food, and ensures that meat and meat products are slaughtered and processed under strictly regulated sanitary conditions. The Federal Agriculture Improvement and Reform Act, also known as FAIR, helps farmers and ranchers who produce food and natural resources with insurance. So they produce a fixed government payments depending on the current farm prices and the production. The National Environmental Policy Act is involved in promoting the enhancement of the environment and establishing the President's Council on the Environmental Quality. This law was enacted on January 1st, 1970. There was a petition on the involuntary anti-mortem inspection of the horses. On November 23, 2005, the USDA received a petition on behalf of the 3 official establishments that were actually slaughtering the horses in the United States, and they requested that an infirm final rule help provide for a voluntary fee of service and anti-mortem inspections of the horses under the AMA. The petition also requested that the USDA provide the voluntary fee-for-service transportation related to the inspection of equines to slaughter under the Agricultural Marketing Act. And the ruling or conclusion of the case is that the U.S. District Court for the District of Columbia sided with the plaintiffs, finding that the USDA had violated federal environmental protection laws. The court agreed in Johanns that the USDA was required to assess the environmental effects of horse slaughter operations pursuant to NAPA before it sued a fee-for-service anti-mortem horse slaughter inspection system. The district court granted summary judgment in favor of the Animal Welfare Institute and its co-plaintiffs. The Cable International Inc., a horse slaughter facility in Illinois, had appealed before the district court as one of the affected businesses. In ruling of Johanns, all domestic horse slaughter facilities ceased operations by 2007. Since then, no horses have been slaughtered for commercial production in the United States. For the Cable International Inc., they filed an appeal, but the appeal was later dismissed as a moot when the company went out of business due to the passage of legislation in Illinois banning horse slaughters. And this slide provides you with my references.